So before, I guess, he testifies, that may be something we need.
But you don't have it right this minute?
I don't have
it.
this. Yeah, I'm sorry, and I could double check. I know Ms. Ray, our paralegal, is printing out some materials, and that was one of the materials I've asked her to print it out. I could try to contact her and ask her that she makes that a priority.
I just thought we could do it now, but if it's not here.
Do you anticipate that the tape will be played soon after the detective gets on the stand, or do you have some?
I do have some stuff, some questions to ask him, but probably 20 minutes or so.
All right. So we'll need that as soon as possible. It sounds like we can put the detective on. One plan would just be to go until we get to the place where you intend to publish that exhibit, and then we can deal with those objections. If we have a more convenient breaking point, we'll do it earlier, but that's probably as good a place as any.
And I just learned that Mr. Bumpers has been found, so that may give us a little bit more time as well. So he's on his way. So
all right, good.
And the other information that was sort of trying to get as far as you and the district attorney's honor is that there's a problem with the printer in the PD's office, but somebody is helping Miss Ray, and so that should be down here soon.
Okay, very good. All right, if there's nothing else, then let's go ahead and bring the jurors in, please. Welcome back. Hope you had a good, restful weekend. I believe we're ready to proceed. If you'll again check, make sure that you have your notebooks in front of you, and we'll ask of the state, is there further evidence for the state?
yes, Your Honor. Good morning, Your Honor. The next witness for the state of North Carolina would be Mr. James Jones.
You get your place your left hand on the Bible and raise your right, please. Do you solemnly swear the testimony you give this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. Please be seated.
Excuse me.
All right, Mr. Waller?
Yes, sir. Good morning, Mr. Jones.
Good morning.
Will you please state your name for us?
My name is James Jones.
And Mr. Jones, you don't have to give us your exact address, but where do you live, sir?
I live in Garland, North Carolina.
How long have you lived in Garner?
I bought the house in '86.
So been here quite some time.
Yes, sir. Yes, sir.
And Mr. Jones, are you currently employed?
Yes, sir.
How are you employed?
I'm employed at the Super 8 motel at 3801 Capitol Boulevard here in Raleigh.
How long have you been with that Super 8 motel?
I've been with the company over 20 years. I've been at that hotel for 12 years.
You said with the company 20 years.
Yes, sir.
And what's the larger company that owns that Super 8 motel?
It's Karen Krishner Incorporated. It used to be Patel and Patel.
And are you currently a full-time employee there at the Super 8 motel?
No, I'm part-time. Yeah.
Are you kind of enjoying a little bit of a retirement?
Yes, sir.
Sir. Back in May of 2013, Mr. Jones, were you still employed at that same Super 8 motel off of Capitol Boulevard?
Yes, sir. I was a manager at the time.
And what are your duties as a manager at that Super 8?
Basically, you run the hotel for the ownership. You manage the employees. You have clerks. You have maintenance crew and housekeepers. Those are your main employees, and you also supervise them as far as reservations, coordinating groups that are coming in. Super 8 is an economy hotel, and we deal a lot with tradesmen, guys who are construction guys, and we keep to keep the rate low for those kind of tradesman type people.
And if, as part of a manager, do you sometimes work the check-in desk and check-out desk?
Yes, sir. Sometimes. Mm-hmm.
Could you tell us a little bit about, if someone walked in off the street, how they would make a reservation there at the hotel?
Okay, walk-ins, we would, you give them your spiel, ask them, what type of room they want. And once they determine they want the room at that rate, you would then ask for the ID. And then you would go through the process of checking them in. And on the ID, when you check them in with the ID, there's a place for, your ID. And we also get a phone number for them. And they ask the number of personnel that are going to be in the room. And once you've done that and processed them in and they've made the payment of the credit card or whatever, you give them a key and they take off to the room.
And you said that they can pay with a credit card, or you also allowed to pay with cash?
Yeah, yeah. Well, most economies, they'll still, let you pay with cash or credit card.
Do you have to? Is a credit card required to get a room there at Super 8 or something?
No, sir. We don't require a credit card. We don't require a deposit of any type. We just a lot of hotels do that, but we don't. And you have the ID and the address. If there's any problem, then we deal with it in that manner.
And Mr. Jones, as part of the regular course of business there at Super 8, do you maintain records of when an individual rents a room from your hotel?
Yes, sir, we do.
And is it in a database or on a computer somewhere?
On the computer, yes, sir.
May I approach the witness, Your Honor?
Yes, sir.
Mr. Jones, I'm going to approach you with what has previously been marked for identification purposes, State's Exhibits number 68 and number 69. Mr. Jones, if you'll take a look at those two documents and tell me if you recognize what they are.
Okay, the first one is a folio, which is just a receipt.
Okay. And when you say the first one, just for record purposes,
First is number 68.
That's 68?
Yes, sir.
Okay, and you said that's a folio?
Right, it's called a folio, which is basically a receipt. They also do a reg card, which we don't have here, which they sign. And it gives the person's address, name, how many people in the room, what he paid, and it has an account number on it.
And 69, what does that document?
69, this document tells you, it's the detail log. It tells you what time he checked in, what time he checked out, who checked him in and who checked him out. And it tells whether or not he was a walk-in or whether or not they had a reservation.
And states exhibits number 68 and 69, sir, that folio and then the account log, do they appear to be documents that would be kept in the regular course of business there at that Super 8 motel?
Yes, sir. You would have one of these on every person that checks in.
And this document, sir, these two documents, do they pertain or do they reference the date of May 15th of 2013?
Yes, sir.
And Mr. Jones, have you been asked as a manager of the Super 8 motel to review those documents?
Yes, sir.
And do those documents appear to be a fair and accurate representation of the type of documents that would be kept at the Super 8 motel to document customers that you have come through?
Yes, sir.
Your Honor, this time I would ask to introduce State's Exhibit number 68 and 69 into evidence.
Any objection? They're allowed.
Let's start with number 69, Mr. Jones. And again, I believe you said that was the log.
Yes, sir.
And again, what type of account log is that?
It's a detail log. And like I say, it tells the person that checked them in and the person that checked them out, tells the time that he checked in and checked out. The only thing with the check-in time, is definite because he's standing there. The checkout time, a lot of people go to hotels, they don't check out. They just leave. So once the housekeepers or whatever have determined that the person has left, then they call the front desk and they check them out.
And Mr. Jones, looking at State's Exhibit number 69, can you tell who the occupant of that room was that morning, sir?
Yes, sir.
Who was that?
It was Ronald Anthony Jr.
I'm sorry?
Ronald Anthony Jr. It says.
That's how it's listed there.
Mm-hmm.
And in reviewing those documents, sir, can you tell the members of the jury what time Mr. Anthony would have checked in that morning?
He checked in at 0325
So 3:25
a.m. Yes.
And can you tell in reviewing those documents whether or not he had a reservation?
He had no reservation. It says walk-in.
And then where on that document, sir, is walk-in noted?
It says right here the date and the time that he checked in, and it has a W there for walk-in.
So under, I think type there's a column that's labeled type.
Type, yes, sir. Type,
And there's a W listed under that.
yes, sir.
And that stands for walk-in.
Walk-in.
In reviewing that document, Mr. Jones, can you tell us what time he checked out the next morning?
The next morning, his checkout time was 11:34.
And again, from that document, can you tell whether or not he actually came to the counter and turned in his key or whatever, or whether or not he just left?
No, I cannot.
Unable to just.
I'm unable to do that. No.
When he checked in there at 3:25 a.m., can you tell the members of the jury how he paid for that room?
He paid cash.
And how do you know that?
It says right here on your number 68. He's paid cash.
You mentioned earlier that you get a phone number and an ID number from someone when they check in on State's Exhibit 68. Is there a phone number and ID reference?
We have a phone number and we have an ID number.
What is the phone number that's listed for Mr. Anthony?
919-706-2137.
And then you said there was an ID number as well. What is that ID number?
The ID number is 3352-8045.
And can you tell from that document, Mr. Jones, whether or not that's a North Carolina ID card or if it's a North Carolina driver's license?
I can tell that it is a North Carolina ID card.
It's just an ID card?
Yes, sir, it's an ID. It would have, which says ID or NCDL for driver's license.
So the fact that it says ID would mean it was
And
an ID card and not a license?
Yes, sir.
Let me see number 69 with Mr. Jones. In looking through the State's Exhibit number 69, can you tell how many individuals checked in or how many individuals are listed there on the reservation?
There are 2 individuals listed on the reservation.
And I guess to be more clear, are there 2 names on the reservation or is it just his?
No, sir. When the person checks in, unless they want that person to access the key or whatever, we get the 1 name. But we do ask how many people, and they say 2, and he said 2.
And so 2 is listed on this document, but Mr. Jones, and based on your experience there at the hotel, sometimes people say 2 people and then more people may be in the room.
Right. Yes, right. They normally, if there's, if it's not a child or whatever, it's 3 or 4 people, then that's an extra charge. And what they do, they say 1. Sometimes they say it's 2 people standing there, they say 1. And then you look on the camera and they go to the room, it's 3 or 4. So,
So the fact that 2 people is listed on that
yeah,
document,
right. It may be 3 or 4, 5, whatever.
so y'all don't necessarily take a head count of who walks in?
Well, if the clerk if I'm working and there's 3 or 4 people go in the room, then I'm going to call the room and say, are they staying? If they're staying, you got to pay. If not, whatever.
But does that happen?
That doesn't happen a lot of times, particularly at that time in the morning. There's at 035 and 325, and it probably didn't happen.
See those some more? The address that was provided to the clerk there that night, can you tell us what address was provided to the clerk?
The address that was provided to the clerk was, excuse me, 7425 Bud Drive, Wake Forest, North Carolina, 27587.
And whose address does that appear to be, Mr. Jones?
That appears to be Mr. Anthony's address.
And just how much did they pay for the room there?
Okay, they paid $67.65.
And that was all in cash.
Yes, sir.
Mr. Jones, you mentioned a moment ago about video, that sometimes you'll see a video of someone going into a room and see 3 or 4 people.
Mm-hmm.
Do you know what type of video system the motel had back in May of 2013?
Yeah, it was an old system, and the one he has now, he has updated it, but that one was an old system. Yeah.
And when you say it was an old system, do you know if it recorded, if it had the capability to record a night such as May 14th?
No, we couldn't go back and get that. No.
Was it just kind of like a live feed?
Right, yes, sir.
And now the hotel has updated to
Right, they're right, it was good.
that it could record,
They can record and go back and get it, yes, sir.
but not as of May of 2000.
No, sir.
What room did they stay in there, Mr. Jones?
They stayed in room 301.
And how many floors does that Super 8 motel have?
The Super 8 has 4 floors.
Any record of any disturbance based on the documents you have there in front of you? Any issues, troubles that?
No, sir. And then if they had been, the clerk would have noted it on, and where we could see it, not on this. And I've looked at it, there was no record of it, of any disturbance.
So checked in at 3:25 a.m. and checked out at 11:34 the next morning?
That's correct.
Or the same morning, I guess I should say.
Right.
Thank you, Mr. Jones. I don't have any further questions at this time.
Okay.
Cross-examination, Ms. D?
Albert?
Yes, please.
Mr. Jones, can I have those documents for a second? So you were not the person who checked Mr. Anthony in that night, correct?
No.
And that's another item of information that you can tell by looking at the records that are in front of you, correct?
Yes, ma'am.
So looking at those records, can you tell the jury who it appears was the person who checked Mr. Anthony in?
Say again?
Can you tell the jury who, according to the records, was the person who checked Mr. Anthony in?
Yes, it was Mr. Smith. He's left the hotel.
Okay.
He lives in Georgia now.
Okay.
Yeah.
So you're here today telling us about what those records mean and explaining to us what the different codes in your system represent, correct?
Correct.
So that the jury can get a better sense of what information is available in those records.
Yes, ma'am.
But you don't have any firsthand knowledge of what happened that night.
No.
But you can tell from the record that Ronald Anthony checked in about 3 o'clock in the morning, correct? Is that right?
Correct.
And he gave a phone number and his North Carolina ID number. And he said that there would be 2 people in the room.
Correct.
And There weren't any problems from the people when they were there at the hotel.
No, never recorded, no.
And the check-out time is 11:34 in the morning, but that could just be the time that housekeeping called and said that there was no longer anybody
Could
in
have
the
been
room.
the time he checked out. 11 o'clock, they don't hassle you about it.
Okay.
They give you the 12.
Okay.
It's not a big deal.
So the check-in time is a little more certain than the check-out time, just
Correct.
based on what you told us earlier. Okay. And I was just a little confused when you were talking about the things that would be in the check-in record. You mentioned a page that would include the signature, and the document that you have has a space for the signature, but it's not signed.
Right. Right. There is another document, which is the registration card. What's the registration? Yeah, which had the signature.
That's what I understood you to be saying. So that there's anher page that would have had a signed card,
Right.
but it's
But-
just not included in the
Correct,
records that are there.
Correct. But well, can I explain this to you? If Mr. Anthony's name is there and his address is there and his ID number is there, then that was who was there. And when the guy's standing there and we're looking at him and
That's clearly wrong.
right.
And that's clearly verified by everything you have.
Right.
And it's just that, for whatever reason, one page of what would normally be there with the check-in documents isn't there. But it's not because anything strange or mysterious happened. Right.
Correct.
Okay. Thank you.
Thank you. Redirect.
I should have asked you on direct, Mr. Jones, what type of room was this, sir?
301 was a double room, 2 beds.
So it would have had 2 queen beds? Or
No, they have 2 single beds. No.
Thank you, Mr. Jones.
Okay.
Anything further, Ms. D? Thank you, sir. You may step down. If you'll leave those papers right there, sir. Very good. Thank you. Any objections to this witness being excused? Sir, you're released from your subpoena and you're free to go, sir. Further evidence for the state?
Yes, Your Honor, may, say we call Julius Bumpers to the stand. And if I'm approaching the previous documents.
Yes, sir.
Place your left hand on the Bible, raise your right, please. Please stand.
Go ahead and stand up, sir, for us. Thank you.
Do you solemnly swear?
Sounds good.
Do you solemnly swear the testimony you give this court shall be the truth, the whole truth, nothing but the truth, so help you God?
Yes, ma'am.
Thank you, sir. Please be seated.
Mr. Waller?
Thank you, Your Honor. Mr. Bumpers, good morning, sir. Will you please state your name for the record?
Julius Bumpers.
All right, Mr. Bumpers, I'm gonna need you to do me a favor. I need you to speak up into that microphone, okay, so all these people can hear what you're gonna say, all right? Can you spell your first and last name for us?
Julious Bumpers.
Mr. Bumpers, you don't have to tell me your exact address, but where do you live here in Wake County?
Rockaway Road.
How long have you lived here in Wake County?
10 years.
And Mr. Bumpers, are you employed at this time, sir?
Not right now.
I'm sorry?
Not right now.
Mr. Bumpers, I want to turn your attention back to May of 2013, okay?
Okay.
At some point in May of 2013, did you come into possession of a Lenovo laptop?
I did.
How did you come into possession of that laptop?
I met up with them at the McDonald's on Traywood Road.
And when you say you met up with them, who are you referring to?
White lady and a dark black man.
The dark black man, do you know his name?
No, sir.
How did you come into contact with these individuals to purchase or to obtain a laptop?
Dad went to eat at Taco Bell, and one of my buddies, he worked at Taco Bell, and I was looking for a laptop at the time. So they called me.
And then, Mr. Bumpers, did you know this, this black male prior to obtaining this laptop from him?
No, sir.
And how about the white female? Did you know her?
No, sir.
Where did you obtain this laptop, sir?
At the McDonald's on Trewick Road.
And how were the two of you gonna, were you gonna purchase this laptop? Was he gonna give it to you? How was
I purchased.
It was gonna be a purchase? And did you in fact purchase the laptop?
Yes.
How much money did you pay for the laptop?
$250.
Besides paying him cash, was there any other arrangement that the two of you made in terms of payment?
No, sir.
Were you going to tattoos for him or anything like that?
No, sir.
Okay, so $250 for the laptop.
Yes, sir.
What did you have any problem getting this laptop from this black man?
No, sir.
What was the white female doing when the laptop was purchased?
They was both together and it was just regular.
Was she the one selling it, or was the black?
Both of them together.
After you any issues with getting the laptop?
No,
Y'all
sir.
fight about it or anything like that?
No, sir.
Did you negotiate over the price?
No, no, sir.
After you got the laptop, what did you do with it, sir?
Went home.
I'm sorry?
Went home.
Oh, you went home. I thought you said well, I'm sorry. And what did you do with the laptop once you got home?
Played with it for a little bit. Yeah.
I'm sorry.
Go ahead.
At some point, were you contacted by the Raleigh Police Department looking for that laptop?
Yeah, the next day.
And when you were contacted about the laptop, what did you tell the police officers?
I got it and come get it.
Okay. Where did they come get that laptop from you, sir?
From the elementary school on Rockway Road.
Did you give them any trouble about giving the laptop back?
No, sir.
Mr. Bumpers, when you gave that laptop back to the police officers, did they tell you kind of why they were looking for it?
Yes.
All right, what did they tell you?
It was involved in a murder case.
Prior to them telling you that the laptop was involved with the murder case, did you have any knowledge about where that laptop came from?
No, sir.
Did you think there was anything wrong with it?
No, sir.
And did you know at any time that it was associated with a murder case prior to the officers telling you?
No, sir.
Did you give the officers any trouble when giving them the laptop back?
No, sir.
Were you cooperative with them?
Yes, sir.
Did you ever get your money back?
No, sir.
May I approach the other shrine?
Yes.
Mr. Bumpers, I'm going to show you what has previously been identified as State's Exhibit number 24A, and if this has a sticker. Sorry. Now has been marked for identification purposes as 25B. Do you recognize 25A and 25B?
Yes, sir.
Okay. 24, 24A and 24B. Do you recognize 24A?
Yes, sir.
What is 24A?
The laptop that I purchased.
Okay. Does it appear to be the orange laptop?
Yes, sir.
Does it appear to be in the same or substantially same condition as when you got it from that individual?
Yes, sir.
When I say the name Ronald Anthony, do you know who Ronald Anthony is?
Uh-huh.
Do you know this defendant, Travion Smith?
Uh-huh.
He's not the one you purchased the laptop from, though.
Uh-huh.
It was another guy.
Yeah.
I'm going to open it up. That look like the inside.
Yes, sir.
Were you able to get into this laptop? You said you played with it. Did you have to break in a passcode, or did they tell you a passcode?
They had the passcode and everything.
I'm sorry?
Said they had the passcode.
It did not have a passcode?
They did have the passcode, so I had the passcode and got right into it.
There's a sticker that says Taz Rue and Fatman87.
Mm-hmm.
Were those the identifying passcodes that you used?
Yep.
User ID and passcode? Okay. And 24B, excuse me, is that the cord that came with it?
Yes, sir.
Okay. Any changes or alterations to either one of these, Mr. Bumpers? Mr. Bumpers, when you gave this laptop to the police officers, do you recall if it was a Detective Gibney that you gave it to? Do you recall the name?
I don't recall the name, but probably so.
Sarah Redden, do you know Sarah Redden by any chance?
No.
Don't know that name either. If I may have just a moment, Ron.
Yes, sir.
Mr. Bumpers, back in May of 2013, where were you working at that point, sir?
2013. I was probably working at the Honda Auto Park.
Did you do anything on the side? I mentioned tattoos earlier. At some point, were you working at a tattoo shop?
Yes.
Okay. And so in May of 2013, were you working at a tattoo shop?
Yeah.
You were?
Yeah.
You were?
Yeah.
You just have to say yes or no for this.
Yes, sir.
All right. And does the date of May 22nd of 2013, does that sound about right for when the police officers took the computer from you?
It was so long ago. Probably so.
And well, that's fine. Can clear that up with the detectives a little bit. But if we use the date of May 22nd of 2013 as the day you returned the laptop or gave the laptop to the officers, can you recall when it was that you actually purchased the laptop?
May 25th.
I'm
May
sorry.
25th.
Okay, but it had to have been prior to May 22nd.
Oh, you said the 22nd? Yeah, the day before.
So it would have been the day before,
Yeah.
the 21st.
Yeah.
You got dreads now. Did you have dreads back in May of 2013?
No, sir.
May I approach the clerk briefly on?
Yes, sir.
May I approach the clerk?
Yes.
Mr. Bumpers, I'm going to approach you with what has previously been introduced into evidence as a picture of Ronald Anthony, State's Exhibit number 16. Do you recognize that individual?
Yes.
You do? All right. And I know I'm standing here in front of you now, but make sure you speak up so that all these folks can hear you.
Yes.
And who is that individual?
That's the one that purchased me a laptop.
The one you bought the
They
laptop?
bought the laptop from. My man.
Thank you, Mr. Bumpers. I don't have any further questions for Mr. Bumpers.
Thank you. Mr. Brown?
Yeah, Mr. Brown wanted to look at something that I approached.
Yes.
Mr. Bumpus, do you remember when you got the laptop that it had a password in it?
Yes.
And do you remember that password was Tazru?
Yes.
That's spelled T-A-Z-R-U?
Yes.
And that was the password that was provided to you by the man that you've identified as Ronald Anthony?
Yes, sir.
And do you remember at the time that you talked to the police, that you identified, that you said you'd seen the photos of the people on the news?
Yes.
And it was not Mr. Smith.
No, sir.
It was, you identified the other pictures as being the man, who we now know as Ronald Anthony,
Yes, sir.
and that you'd seen the woman on the pictures. Does the name now Sarah Redden ring a bell as the other person you had identified?
That must be the white lady.
Okay. Thank you. I have no further questions.
Mr. Waller. Thank you, sir. You may step down. Any objection to this witness being released? No, sir. Sir, you're released from your subpoena. You're free to go. Thank you. Further evidence for the state?
State calls Detective Gibney.
Place your left hand on the Bible, raise your right, please. Do you solemnly swear the testimony you give this court shall be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Thank you, sir. Please be seated.
Thank you.
Ms. Shakita?
State your name, sir,
My name is Eric Gibney.
and how are you employed?
I'm a detective with the Raleigh Police Department.
How long have you been employed with the Raleigh Police Department?
Approximately 16 years.
Are you currently assigned to a particular unit within the Raleigh Police Department?
Yes, I am. I'm with the homicide unit.
How long, first of all, have you been involved in investigations?
Since 2007.
Okay. And how long specifically have you been with the homicide unit?
Approximately 4 years.
Were you in that same unit, that is the homicide unit, back in May of 2013?
Yes, I was.
Did you have some duties and responsibilities in the death of Melissa Huggins-Jones?
Yes, I did.
Do you recall when you first got involved in this case?
Yes, we were working day shift, and upon arrival to work that morning, I was notified that a homicide had occurred on Allister Drive in Raleigh.
We've heard a lot of testimony from some of the other members of your unit about the fact that Detective Brady was assigned to be sort of the lead agent.
Yes.
When you are working with, on a homicide or one of this nature, were you in communication with Detective Brady and the other members of your team?
Yes.
What were some of your early responsibilities that morning once you all had found out about the death of Melissa?
I remained at the police station. I was informed that there would be some family members and potential witnesses, a few construction workers that would be arriving at the police station. I remained at the Atlantic Ave police station to interview those people.
And so is it unusual then for some folks to be at the scene and some folks to stay back and talk to folks?
No.
Okay. Who just generally did you speak with on that early morning?
I spoke with multiple family members, and I spoke with Thomas Finch, who is a construction worker in the area.
And did you talk with Mr. Finn about what information he had?
I did.
Okay. And after you were asked to talk to Mr. Finn, you said you spoke with several family members?
Yes.
Initially, why do you want to talk with family members?
We want to gather a background from the victim, try to establish an early motive, any problems that she may have been having with anybody, basically get a history of her background.
And when you met with her family, were you aware of whether her parents were still married or if they had separated?
I was informed that they had separated.
Okay. And so to speak, she had two sets of parents.
She did,
Is that safe to
yes.
say?
Yes, ma'am.
Did you speak with all of those folks? That is the Huggins and the Wallaces?
I did.
And again, you said you were trying to find a motive or find out if she had any problems early on. Did you speak with any other folks other than family members?
I spoke with a few of Miss Huggins-Jones' Raleigh-based friends.
And again, what kind of information are you trying to get from them?
Just a historical background into her social life, any problems she may be having, help identify any names, that sort of information. And as a result of all of those interviews, nothing really jumped out as an angle we needed to work right away.
Okay. And at that point, you said you were at the Atlantic Avenue station interviewing folks. Did you go out to the crime scene?
I did.
And what, if anything, did you do when you went out to the crime scene?
Detective Falk and I went out to the crime scene, and we started canvassing the neighborhood, which is basically knocking on all the doors, speaking with nearby residents. And while doing so, we began to discover that multiple vehicles had been broken into that night as well.
And once you realized that you had some car break-ins, what do you do, at least from a Raleigh Police Department perspective? Is it a different investigation? Is it linked, or what do you do at that point?
Well, we first tried to determine if they were related to this homicide, and at first we really didn't know if they were related, but we worked it as it's extremely ironic in that area for multiple vehicles to have been broken into and a homicide occur within the same area. So we called CCBI out, and every victim we found of car break-ins, we requested each vehicle be processed.
And with a car break-in itself, is that usual for, that is, the CCBI to come out and process the vehicles?
It can be, depending on how the vehicle appears to have been broken into, yes.
But in this case, you've already found out that there's a homicide in the area. Was it important that you try and also process those?
Absolutely.
And when you were noticing that cars, or you said you found out when you got out there that cars had been broken into, did you have occasion to go to the garage area that we've talked about in court this week?
Yes, ma'am.
And what, if anything, did you notice about that garage?
The parking deck had some black-colored wrought iron sort of gates. One section of them appeared to have been slightly pried open a little bit. It looked to me so a person or persons could squeeze in between the gates.
And once you saw that, what did you do with that information?
I requested CCBI to respond to that area as well and photograph it and process it the best they could forensically.
And you said that you had realized that there had been some car break-ins. Did you try and identify the owners of those cars and speak with them?
Yes, we did.
Okay. And you said at this point you were working with Detective Falk?
Yes.
Did you have any other responsibilities there in the Allister area that day?
Not on that specific day. It took us several hours working the vehicle break-ins.
And you said that you had interviewed folks early on and no real leads came up on that early morning. During the course of the investigation, did you speak with anyone who might have potential information on the case?
Eventually, yes.
Okay. And not on the first day, but for example, if folks would call in, was your unit asked to follow up with any information they may have?
Yes, at that point we were soliciting
Okay.
for information, yes.
And what do you mean soliciting for information?
Well, we actually conducted a traffic checkpoint where we stopped all cars coming and going on Six Forks Road during specific hours that we believed the crime to have occurred, and we handed out information-seeking flyers.
Why do you do a traffic checkpoint? What was the purpose of that?
Well, we conducted the checkpoint in a time frame which we believed the crime to have occurred with the hopes that that would be the same people that may have been driving during that same time frame, trying to figure out maybe somebody saw something that they didn't think was significant. However, now they realized it was significant.
And so you said you actually handed out flyers, and what were those flyers? Were they encouraging people to do anything?
It was just information-seeking
Okay.
flyers based on what we had at that time.
You said that you didn't have any additional responsibilities at the crime scene, or crime scenes, I guess, at this point. On that very first day, did you have occasion to go back?
I did.
And do you recall about when that was?
Yes, on May 16th, Detective Morse and I responded back to the crime scene in an effort to just re-walk the entire area, search for any piece of evidence, any clues, anything that we could find, direction of travel for the suspects, anything.
And why do you want to do that?
It's possible to miss stuff early on. It's possible that evidence could be dropped or lost by a potential suspect or suspects, and we wanted to make sure it was a very large area. We did not have a direction to travel. We did not know how the suspects fled. Therefore, we wanted to walk all the areas and just do our best to make sure we're not missing anything.
And what, if anything, did you find, or what happened when you rewalked the outside area?
As we were walking a chain link fenced area across the street from Ms. Huggins-Jones' apartment, Detective Morse and I located a pink-colored Victoria's Secret jewelry box that was lying next to the chain link fence in a patch of poison ivy and weeds.
May I approach the witness, Judge?
Yes.
I'm going to show you what's already been identified and marked as State's Exhibit 50, containing State's Exhibit 50A. Do you recognize this?
Yes, ma'am.
And what is State's Exhibit 50A?
It's a pink-colored Victoria's Secret rectangular-shaped jewelry box.
And is this the one that you all found that day?
Yes, ma'am.
Once you found it, what, if anything, did you do to collect it or yourself, or what did you do?
We call it CCBI.
I'm going to show you, Your Honor, with the court's permission, State's Exhibit 5, and ask Detective, sorry, not to knock you out with it. Turn it back around this way. Do you recognize State's Exhibit 5?
Yes, this is a layout, an aerial photo of the entire area.
And earlier in the testimony, the blue pushpin mark has been identified as the apartment building where Melissa was killed. Can you use State's Exhibit 5 to show us the general area where you found State's Exhibit 50A?
Yes. This is Ramblewood Drive. Right across the street from Ramblewood Drive is a chain link fence and a strip of bushes. Directly to the left of that chain link fence is a very, very high concrete wall, which separates basically this area from the traffic on Six Forks Road. And right in this area, if you're facing this wall, just to the right is, in that patch right there, is where we found the pink jewelry box.
And was it just laying on the ground?
It was thick brush, and the brush appeared to have been disturbed, and it was lying on the ground, yes.
And you said once you all found State's Exhibit 50A, then you contacted CCBI to collect it?
Yes, ma'am.
Had you had prior information about a pink Victoria's Secret box?
No, ma'am.
Okay. And so at the time, did you know whether or not it had anything to do with this case?
No, ma'am.
Did you find anything else unusual or make note of anything else unusual on the 16th now when you're walking around?
We just noticed that that section of bushes, kind of weeds, were a little disturbed, and it was an odd place for them to have been disturbed.
Did you have any additional responsibilities there outside in the crime scene on the 16th?
No, ma'am.
Were you familiar with that North Hills area? I mean, as a Raleigh detective?
Yes,
Okay.
yes, ma'am.
Did you know whether you, yourself, or other folks were trying to see if there were any sort of surveillance cameras in the area?
Yes, ma'am.
Okay. And what, if anything, did you do about that?
I drove the area. A few of us did because there's buildings going up left and right, and we weren't quite sure where there could be surveillance, new surveillance cameras. So we drove the area searching for any new buildings that we weren't aware of that would have surveillance cameras, and basically provided a list of those locations to somebody in the detective unit who's assigned to obtain video surveillance.
Do you have a specific person within RPD that does sort of in charge of surveillance videos?
Yes, ma'am.
And did you pass along that information to that person?
Yes, ma'am.
At some point, were you made aware of the break-in to the downstairs leasing office apartment?
Yes, ma'am.
And we've talked a lot about the computers that were stolen. Did you have some responsibilities with respect to those computers?
Yes, ma'am.
And can you tell us a little bit about when you first got involved, that there may be a lead on the computers?
Yes, ma'am. On May 21st, Detective Morse informed me that he believes he has located one of the stolen computers on Craigslist. He had developed a Michael McCullum subject as a potential suspect, either in possession, trying to sell the computer. We weren't really sure. So we attempted to establish an undercover operation to purchase that computer.
And was that undercover operation successful in purchasing the computer?
Not at that point, no, but eventually, yes.
Okay. And so when it initially wasn't, Detective Morse testified, I guess, a couple days ago that the buyer didn't show up. Is that what your understanding was?
Yes, ma'am.
Okay. And when you had set up that undercover operation, were there units in place to monitor the potential sale?
Yes, we had undercover officers out there.
When that fell through, what did you all do next as a unit?
Well, I was informed, I remained at the police station, and I was informed that our undercover units that were out in the Wake Forest area, which is where McCollum's residence is, that they had observed a subject, two subjects potentially involved in the sale of that computer, or at least associated with McCollum's residence, and they had detained both of them, and they were going to be transported to the office to be interviewed.
And did you have any responsibilities with one or more of those folks that were brought to the police department?
I did.
Who did you speak with?
I first spoke with Chandra Millhouse.
And what connection, if any, did she have either to McCollum's residence or McCollum himself?
She has been dating McCollum for approximately 2 years at that time.
And did you talk with her about any information she may have as it related to the computers?
Yes, ma'am.
Would you describe her as cooperative, or how would you describe her in your interaction?
She was very cooperative.
Who else did you speak with, if anyone, on that day? That is the 21st now.
I spoke with Travion Smith.
And when you speak with a particular subject in a case that involves a homicide investigation, what do you do to document the interview that you have?
We record it on a program we have called Video Oversight. He's basically seated in a room, and all my interactions with him are recorded.
Once you, for example, start the interview, does the video oversight or the camera keep rolling?
Yes.
Okay. Can you go in and edit the interview in any way? That is, edit portions in or out of the interview?
I cannot, no.
And did you, in fact, record the interview that you had with the defendant?
Yes, ma'am.
At some point during your interaction with the defendant, did you request certain items that he was wearing to be handed over to the police department?
Yes, ma'am.
And what, if anything, did you ask of him in that regard?
I requested his sneakers, his tennis shoes.
You want me to approach the witness?
Yes.
I'm going to show you what's previously been identified as State's Exhibit 60. And I'm going to take out the contents, which are State's Exhibit 60B and 60A. Do you recognize these tennis shoes?
Yes, ma'am.
And how do you recognize them?
Those are the shoes that Mr. Smith was wearing when I interviewed him.
And so when you say he was wearing them, did you actually ask him to take them off his person and take them?
Yes.
And were you the one that collected them on the 21st?
Yes, ma'am.
Looking at State's Exhibit 60, the the bag containing 60 A and B, do you recognize at least the handwriting in the top portion?
Yes, that's my handwriting.
And we've talked with several other detectives. Once you took these, did you seal them in a sealed fashion?
Yes, ma'am.
Does it appear that other folks have had occasion to examine or look at these items?
Yes, ma'am.
And are you familiar with items, for example, that are sent off for testing at the SBI crime lab?
Yes, ma'am.
And do you recognize markings on them consistent with, for example, going to CCBI or the SBI?
Yes, ma'am.
So is it safe to say after you sealed these, several folks had looked at them or done something with these?
Yes.
Looking at this bag?
Yes, ma'am.
In addition to collecting the defendant's shoes, did you collect anything else from him?
Yes.
And what is that?
I requested that he voluntarily submit to called a buccal swab. It's basically a DNA sample, and he did, and I collected that.
You had 69, 68, right?
Yep.
May I approach witness gentleman?
Yes, ma'am.
I'm going to show you two envelopes, the first of which I'll mark as State's Exhibit 70 and ask if you recognize State's Exhibit 70.
Yes, ma'am.
And what is State's Exhibit 70?
That is a buccal swab, Travion Smith.
And how do you know that it's actually the defendant's buccal swab?
His name is on there as a prisoner or suspect, and the evidence description states buccal swab.
And you said that you asked him to submit to a swab, is that correct?
Yes, ma'am.
Can you tell the jury, generally speaking, how you actually get the sample or the swab itself?
Yes, we have packages that are sealed and dated. In each package, there are two basically long Q-tips, and each one is assigned a long, narrow box with it. So what we'll do is we'll take one Q-tip and swab the inside cheek of the mouth on one side, stick it straight in the cardboard box and seal it, and then we'll do the same on the other side and seal it.
And you said when you first get the swabs themselves, they're sealed. Why is that important?
To ensure they have not been contaminated or tampered with.
Once you took this swab from both sides of his mouth, or one on each side of his mouth, did you again seal them?
Yes, ma'am.
And once the swabs themselves were sealed, did you put them in this envelope and seal the envelope?
Yes, ma'am.
And looking at the back of it, does it appear, and the front of it, does it appear that this sample has also been submitted for further testing?
Yes, ma'am.
Looking at State's Exhibit 71, I'm going to ask if you recognize 71.
Yes, ma'am, I do.
And what is State's Exhibit 71?
That is another buccal swab that I obtained from Sarah Redding.
And do you recall when you got this swab?
That was on the same day.
And it says 5/22. We had talked about 5/21. Have we crossed from 21 into the 22nd at this point?
Yes.
And again, did you take or collect the swabbings from Ms. Redden the same way you described earlier?
Yes, ma'am.
And was that package sealed before you opened it and took the swab?
Yes, ma'am.
And did you seal it up similar to what we've already discussed?
Yes, ma'am.
Likewise, does State's Exhibit 71 appear to have had further testing as well?
Yes, ma'am.
And to be clear, on the 21st into the 22nd, you collected Ms. Redden's swab. Did you have any responsibilities with interviewing her?
No, ma'am.
When you were speaking with the defendant, Travion Smith, do you know about how long it was that you spoke with him?
Approximately 7 hours.
And are you talking to him for 7 hours, or tell us what's happening during that 7 hours?
At that same time, Detective Falk was interviewing another subject, Mr. Anthony, and on occasion I would leave the interview room and we would compare stories basically. And
Sustained as to character, jury's disregard characterization of your conversation.
Did you speak with Detective Falk about his conversation with Ms.
Yes.
Redden? Do you know who was speaking with Sarah Redden?
I believe it was Detective Gill.
Would you also speak with Detective Gill periodically about perhaps what Ms. Redden was saying?
Objection.
As to the form?
Yes, sir.
All right, sustained.
Did you talk with Detective Gill?
Yes, ma'am.
What did you talk to him about?
The nature of the interviews which were being conducted.
And why do you want to get information from the detectives that are speaking to the other parties?
Basically, we're trying to get to the truth.
Overruled.
We want to establish the truth.
And when you would speak, for example, with either Detective Gill or Detective Falk, what would you then do after talking with them?
Reapproach the respective individuals we were interviewing at the time.
And so during that 7 hours, are there times when you would leave the room and then come back in?
Yes, ma'am.
After speaking with the defendant, now we're into May 22nd, did you have occasion to come into contact with Julius Bumpers?
Yes, ma'am.
And how was it that you developed Mr. Bumpers as a potential witness?
On the 22nd, I was informed that some information had been developed indicating that prior to the arrests, two individuals had sold the orange-colored Lenovo laptop to an individual associated with a tattoo shop located on Rock Quarry Road.
And once you got the information about the tattoo shop, what did you do?
Myself and Detective Morris responded to that tattoo shop.
And were you able to identify potential people there, or what did you do when you went there?
We inquired about the computer with some employees. The people we spoke with didn't have any knowledge regarding the computer. However, I left my business card and suggested that they call if any information is developed about that.
And after leaving your business card, what happened?
Approximately an hour later, I received a call from Julius Bumpers.
Did you make efforts to speak with him?
I did.
And where did you speak with him?
I spoke with him over the phone, and then he agreed on meeting me in person, and I drove down to where he was located and met him.
Do you recall where that was?
Yes, that was in the parking lot of Walnut Creek Elementary School.
And at that point, did you speak with him about the knowledge he had about the computers?
Yes, ma'am.
What was he able to tell you about how he came into possession of the computer?
Well, when Julius sat in my vehicle, he handed me the orange computer and the charger. He told me that he had purchased the computer yesterday, being the 21st, at the McDonald's on Capitol Boulevard around 2 o'clock in the afternoon for $300.
And was he able to tell you who he purchased it from?
He was. He told me that he saw 3 arrest photos that we had made the day before, and he stated he purchased a computer from the guy on the left and the white female on the right.
And were you able to figure out what he meant by the guy on the left in terms of who that was?
Yes.
And who was that?
Mr. Anthony.
You said that he handed it over to you, that is the computer and the charging cord. Did he give you any problems, or was he cooperative?
He was cooperative.
May I approach the witness, Judge?
Yes.
I'm going to show you what's been marked previously as States Exhibit 24, 24A, and 24B, and ask if you recognize 24A and B.
Yes, ma'am.
And what is States Exhibit 24A and 24B?
That is the orange Lenovo laptop and the charger for it.
And there appears to be a sort of post-it note on the top. Was it on there when Mr. Bumpers gave it to you?
That I do not recall.
And did you actually collect these items and take them into custody of the Raleigh Police Department?
Yes, ma'am.
And again, did you seal it up like we've talked about the other methods of collecting evidence?
Yes, ma'am.
And does this appear to, is this the exact items that Julius Bumpers provided to you in your car there at the elementary?
Yes, ma'am.
Unlike the other items, does it appear to have been sent off for any further testing?
Does not appear though, as though, no ma'am.
Your Honor, this time the state would move to introduce State's Exhibit 24 containing 24A and 24B into evidence.
Any objection? No, sir. It's allowed.
After speaking with Mr. Bumpers in this case, you said that the arrests had been made. Was that something that had been broadcast on the news?
Yes, ma'am.
Okay. Did you have any further responsibilities in this case?
No, ma'am.
And during the time frame from when you came into work on May 14th through May 22nd, now when you've collected that computer, were you in communication with Detective Brady about all of the information, for example, that you would discover in this case?
Yes, ma'am.
As a unit, were you all speaking to each other?
Yes, ma'am.
Do you have occasion prior to taking the stand this morning to see the DVD that was on this computer, which I'll mark now as State's Exhibit 72?
Yes, ma'am.
Okay. And what was State's Exhibit 72?
The video oversight recording of an interview with Mr. Smith.
And again, after concluding the interview, do you stop, for example, the camera from taping?
Yes, ma'am.
Have you changed or edited or deleted any of the interview, or is State's Exhibit 72 the actual recorded interview that you did with Mr. Smith on the 21st into the 22nd?
No, ma'am.
It is, I might have asked it wrong. It is exactly the copy.
It is exactly, yes, ma'am.
Your Honor, I know that there are some concerns, but I would move at this time to admit State's Exhibit 72.
I think we probably need to discuss.
All right. Okay, so ladies and gentlemen, there's matters I need to talk about with counsel outside the presence of the jury. I'll ask that you step into the deliberation room. I would suspect that we're going to be at least 20 minutes, so you're free to get a cup of coffee, whatever you wish to do, if you wish to leave the deliberation room. While you're there, please recall all the instructions I've given you throughout this trial. Don't talk about this case among yourselves or with anyone else. Don't form or express opinions about the outcome. No media or independent investigation into these matters. No conversations with parties, witnesses, or lawyers. And if you will leave your notebooks in your chairs. If you'll follow the bailiff, please. Outside of the presence of the jury, I'll hear from you, Mr. Brown.
Yes, I have, there are certain items we are not objecting to the entire tape at this point. There are certain items that we believe should be redacted. What I've done, the state has provided us with a PDF part of the conversation. We took a conversation that we have done in a Word document, and I have bolded items that we would object to. So I'm going to hand a copy
That's
to
fine.
Ms. Shakita and one to the court. And I guess I'll just go through if you want to tell what my specific objections are to each items. The document's about 54 pages and 53 pages.
All right. Why don't we just go through it and we can hear from the state. Probably makes the most sense to go ahead and hear from the state as we go through each of the objections.
Yes.
All right.
The first one is on page 1, is the first beginning of it. They talk about him being on probation, and that's why he's here for a probation violation. And we would object on 4-1, 4-2, and 4-3 grounds. I don't believe there's been any evidence about him. There's been about him being kicked out of his home, but at this point I don't believe there's any evidence about Mr. Smith being on probation. I think we can do, if we start the interview just a few seconds into it.
I don't have any objections.
Okay.
Being cut out.
All right.
All right.
So,
And I think I would like, once we make rulings, that you can see where we'll start it, just to make sure we're all on the same page, but I have no objection to editing that out, and it's actually easy to do because it's early on.
Yes, I realize some of these may be more difficult. I realize that was probably the easiest ones, but on the second page, Detective Devonte, don't be stealing my pen. We object in 4-1, 4-2, 4-3 about that.
I think he's joking with him at the time, Josh. My recollection of it is.
I think he probably is.
They're
but-
laughing.
all right, that objection's overruled.
Okay. Going down to the page, you see there's a reference to my probation. There's an inaudible, and I honestly don't remember if it's inaudible based on the state's one as well, but it says my probation out there. It's at the 8/11/34 mark, for the same reasons we previously talked about.
All right. All right, so this is, you say it's inaudible? I don't see the inaudible. I do see the bold.
The bold part about it just says my probation out there. I'm not objecting to the inaudible part. I'm just saying my probation out there.
What's the state's position?
I don't have a position, Judge.
For the same reason.
What is there, I don't believe that the issue of probation has come up I guess the only indirect reference to it perhaps was that the witness who testified about Marijuana Anonymous said that he believed that Mr. Smith and Ms. Redden also had forms, but that I'm not sure that either his memory was correct or
His memory was
It's
not
not.
correct
There's-
on that. I mean,
right.
I mean, we have all of his conditions, and so he was just wrong in that memory.
Right.
I don't know.
And is there any relevance to it? Does the state anticipate that evidence will come in for some other purpose later in the trial? I'm trying
Not
to.
during the guilt innocence phase,
Right.
and we stipulated to the day he was kicked out. Problem is, I guess the bigger issue is I can't remember what he said right before this. I mean, the testimony has been that once he was kicked out of his house, everyone has said he went to live with Ronald and this girl, which has now been identified as Amber. So whatever Your Honor feels appropriate about that.
All right. I'm inclined to allow the objection with respect to probation officer. And then we'll talk about logistics. We'll see how possible it is to redact these portions from the video. Are you intending to hand out a printed transcript of this?
I think it depends on what, not during the case, we may, I knew that these were issues we have it printed. It may be something we seek to introduce into evidence, but I didn't want to do anything until we had these issues.
Right. All right.
Right, no.
The next page is the same issue.
All right. Now, you have in bold on my copy on page 353, you have inaudible.
That I will say that is a typographical mistake.
I see.
Okay, yeah, the inaudible, and then your inaudible at 8/12/23. I was looking at that. It's either, I believe it's typographical error. I cannot think why I would have had it.
Okay. And so now what page are you on?
We're still on page 3, but since my dad got my probation officer to kick me out, that's at the top of the page.
Right. That was the one I thought I just ruled on. Was there another one?
There
I see.
was another reference to
Okay.
page 2, my probation out there.
All right, that's, okay, I'm sorry, I was skipped ahead of you. All right, so that's allowed, and then the next one's allowed as well, on
Yes,
page
and
3.
then- And then I think we go a few pages.
All right, so page 8.
Page 8, maybe the next time we get there. Page 8 through the middle of page 9.
All right, what's your objection?
My objection, Your Honor, this is on 401, 402, 403. It's also improper opinion evidence about whether he is telling the truth or not, both based on 701, if he was an expert, 702, that's improper. I think invades the province of the jury. It would violate due process.
All right, what's the state's response?
It's his interview. It's his interviewing technique, and he gets him to start talking. So while it may be prejudicial, it is what the defendant said. And while it may be prejudicial in that it elicits some information, it's a technique that Detective Gibney will say, got him starting to talk. And I would say there's nothing about opinion evidence, and obviously the jury gets to decide whether or not he's telling the truth.
I would point out he's telling him, you're lying basically throughout this whole thing. This is what's really happening. It doesn't make sense and all. It's going to be highly prejudicial for the jury to hear all of that. And just to say it's an interview technique, it's giving the man's opinion about what's going on. So I think that that should be.
It's also supported in case law that they can tell the defendants that they're lying.
Well, they can tell that there's two issues. The issues of whether it's proper to suppress or not. It's the issues of what the jury hears about that.
All right, I'm going to allow it. I do feel that it's relevant in the context of the entirety of the interview. It places the questions and the answers in context. It illustrates the techniques that were used by the detective to elicit those answers, and it allows the jury to weigh the credibility and the weight of the responses given by the defendant. In terms of the probative value, I find that when balanced with any undue prejudice, I find that it should not be excluded under Rule 403, that the jury is capable of recognizing that this is a question and is capable of discerning, assigning an appropriate weight to it. So I do not find that it's unduly prejudicial in light of its probative value.
Let me just, before we go further, so I do not forget, for purposes of record keeping, can we mark this as some type of exhibit for
Right.
purposes of
Certainly.
of the record, so the rulings will be clear to appellate courts?
Certainly. It'll be the next court's exhibit. I don't know what number we're up to, but the clerk is keeping all of these exhibits in sequential order.
All right, well, thank you. We're going to the next, I think it's sort of, we have similar objections to the next several paragraphs.
All right, so this would be the latter portion of page 9.
A lot of portion of page 9 going almost to the end of page 10.
All right, same objection.
Yes, so the ones that previously made.
State, same response?
Yes, sir.
All right, and I'll make the same ruling. I'm going to allow the questions and responses of Mr. Smith that are on page 9 going through the bottom of page 10.
Okay. I believe the next one, just going through, well, no, I think it goes, I think we're dealing with similar issues on page 11 and 12. And we would have similar objections. And also like to throw in, I think it's another confrontation as well. There's some objections.
And are you, on the confrontation issue, are you looking at a
I'm making,
third party? Is there a hearsay concern? What?
it's not a hearsay concern, it's just the right to confront the witnesses. I am going to come up with some confrontation / hearsay concerns in a moment, some of the other ones. I don't want to be heard more about it, it's just one of the additional items that I want to
Preserve for the record. That's fine. All right, this is the same, and again, the state's position on this?
And we're still talking about 11 and 12?
Yes.
Yes.
All right, I'm going to overrule the objection and allow the testimony on pages 11 and 12, or the questions and answers on page 11 and 12. All right, page 14.
Page 14. This is, we have some of the similar objections, but this one is where we're talking about the hearsay and confrontation clause issues. It's implying that they've talked to Ron and Sarah, and they're putting it all on you. It is clearly getting before the jury the idea that Ron and Sarah are making statements implicating Mr. Smith as the one who did the crime. So I think it's confrontation issues. I think it is for some of the issues we said beforehand. Even if it was offered for another purpose, it would be highly prejudicial. And so confrontation, hearsay, 401, 402, and 403 would be our arguments there.
What's the state's position on that?
Yeah, I would suggest, first of all, that it is what Detective Gibney is saying, so he has the opportunity to cross-examine Detective Gibney about why he said it, should he choose to do that. And so it isn't a hearsay issue. If Your Honor finds that it is a hearsay issue, I would submit that it's not being offered for the truth of the matter, but what Detective Gibney was trying to do in this interview, its probative value certainly is not substantially outweighed by any prejudicial effect, because at this point the defendant starts telling him that he had in fact broken into some cars. And it is an interviewing technique. Had Ron not even said anything, he would be perfectly permissible to say, look, they're pinning it on you, and that's permissible under the case law. So I would submit that, one, the declarant is in fact Detective Gibney, and he's using a strategy to try and get this defendant to talk. And at some point, I believe, prior to this, I think even this defendant says, have you got Ron down here or something? They both ask if the other ones are down there. And so I would submit that it is certainly relevant, and any prejudicial effect does not substantially outweigh its probative value. So I would ask you to allow it.
Yes.
I understand that it is a police technique that they can make up things and all, but the question is, the jury hearing this is going to get the impression that Ron and Sarah are making statements linking Mr. Smith to it and all. And we've done, Mr. Smith as being the one involved and everything else. It's not this detective that I'm worried about cross-examining. It's trying to cross-examine Ron's statement about it, which I cannot do. That's the confrontation problem about it. I think it is highly prejudicial. I think that to explain the office, what the limited value of that it being a technique, which I think has limited probative value, is highly outdone by the prejudicial value. And if I tried to cross-examine and said, this is a common technique and Ron never said such a thing, his response could be appropriately, well, yes, he did. So it's limited to what I can do on that, simply to establish this as a police technique of doing it. This is not a suppression issue. This is an issue of confrontation and motion to eliminate and that type of thing. So I don't think that the case law that Ms. Shakita is talking about is supportive of this proposition. I think we can get out the technique, get out what Mr. Smith said that they wanted to come over without putting in that Ron and Sarah are implicating him in the crime.
And another point that you made earlier, Your Honor, it would make no sense for the tape to say, from a fiend downtown in Heritage Park about 8:30 p.m. you were wearing black jeans and the black Jordans. Is that right? Okay, is that what you're staying with? Okay, and then he says the cars and stuff were true. It just would totally take the interview out of context as well. And so for that reason, in addition to other arguments, I would ask that you allow it.
All right. I am going to allow it. I find that it's not hearsay. It is not being offered for the truth of the matter asserted. The declarant is here and can be cross-examined. I will certainly instruct the jury that they're not to, if requested, that they're not to consider these questions for the truth of the matter asserted, but they are proffered solely for the purposes of an investigative technique to elicit answers from Mr. Smith, and in balancing the probative value versus any undue prejudice, again, I find that the probative value outweighs any undue prejudice.
A couple of logistical questions. I think we would want to have a limiting instruction with it and all, without waiving the fact that we're still objecting to this items with it. Obviously, we do not want to waive our objections to this. I am trying to figure out but on the other hand, I do not want to interrupt the tape. Perhaps do I need to object at the moment that this is being played in the tape, or at the time that the tape is being done with it? I mean, I'm willing to do that.
No, I don't think you need, I mean, the evidence is being offered and received.
Okay.
I mean, there's a motion on the floor to receive the evidence, and you are making your objections. I'm ruling on those objections. I think the record is very clear about where the objections are. So I think the appropriate thing to do, without advising you on how you should do it, is at the prior to me ruling on the motion, if you'll just state that you're objecting for the matters previously noted. I do think that the limiting instruction, we ought to pause the tape somewhere in this proximity and allow either right before this question or right after this question, so that I can then give a limiting instruction that is relevant to the information that they're hearing at that time. I think that's probably the more appropriate way of doing that. So if you can arrange to do that, Mr. Keto.
Before page 9?
Well, I'm looking at page 14.
Right. Okay.
And limiting instruction there is, I'm going to give an instruction that the jury is not to consider this for the truth of the matter asserted, but rather it is being received into evidence solely for the purposes of establishing what questions were asked and the investigatory technique that was used, and the jury is not to consider the truth of these statements made within questions of Detective Gibney. All right. Moving on to page 15.
Yes, sir. And I think this is something similar, but this is in much more detail than the previous items telling them. It's also bringing up the issue of plea bargaining too, which I think is also an issue. So for the same objections based on 401, 402, 403, and confrontation and hearsay and due process, we would object to these items on page 15.
What's the state's position on this?
I think it's exactly the same situation as in page 14. Again, it's the same information that he is presenting to this defendant. Again, it's not hearsay. I don't understand the plea negotiations. I mean, certainly almost every Raleigh Police Department investigation or interrogation talks about, I'm going to call the DA's office and let him know what you're doing. And so for the same reasons on page 14, I would ask that you allow these. Again, it's Detective Gibney's words in an effort to try and get the defendant to talk.
That's key too.
Oh, and another point is, it's interesting, in the middle of that, after Detective Gibney tells him I've talked with them, he wants to know, that is, the defendant wants to know what they're saying. Specifically, the first bolded part of Mr. Smith on page 15, what is that? What are they saying? Which I think is highly relevant and probative and valuable. I mean, relevant and probative.
let me ask, is what's being recounted here by the detective, is it completely made up, or is it based on actual statements that were being given by Mr. Anthony and Ms. Redden at the time? I mean, namely, were they providing this information in other interviews and he was recounting that information, or was this, when Mr. Brown cross-examines this detective, is he going to say it was completely made up? It was just purely an investigatory technique.
I think that you'd have to ask the detective. I know that they were getting information. I just don't know what information he had at this time. So I don't know the answer. I don't want to speak for Detective Goodman. You could ask him.
All right. I'm going to reserve ruling on this one and just see how much more detail we go. I suppose there's a certain point where let's just go on and let me review the rest of the recording and see how much more detail we get into about other statements that are being given in this case, and then I can consider it all in context. All right, so on page 16.
Yes. I would, I'm relaying the same objections that I have beforehand: 401, 402, 403, due process, and confrontation and hearsay. You have two people that you were with that are accusing you of a murder.
All right. All right, we'll continue to hold that one under advisement.
And they go for a while now before we have any. The next one, I believe, is on page 22.
Yes. All right, again, I'll hold this one under advisement.
And I just want to make sure, and I may have said it, but I'm just objecting, and I want to make sure I'm clear on the record on page 22 that it's for the 401, 402, 403 confrontation, hearsay, due process.
All right. All right, on page 28, I believe is the next one.
Yes, sir. Same concerns that we've expressed beforehand under rules 401, 402, 403, due process, hearsay and confrontation. Again, they're talking about Ron's putting it on you, and you're putting it on Ron. The next page, well, Ron's given us details that he said you told him of the inside of the apartment.
Take that one under advisement. Page 33.
Yes, sir. Again, some similar objections, 414, 243, confrontation and hearsay. And this is again page 33. Saying that you took a phone out of there and you threw it up in Wake Forest, smashed it. So why is he, and going back a couple lines, I'm sorry, I should have probably done it in a different order, but so why is he telling us that you got a phone out there and you threw it out in Wake Forest? Again, we're getting exact information that Ron told, is purported to tell the police what happened.
All right.
And maybe even Sarah as well.
I'll take that under advisement. Page 35.
Page 35. And I just wanted to point out on the last one that the phone is a pretty significant part of this case. The first one is more of a reference to some of the concerns we expressed earlier about opinion, evidence, and all, and that's the first bullet one is on page 35. Do you know how hard that is? I'm not saying I don't believe you, but it's hard to swallow the fact that you're so stressed out.
Right. That objection's overruled.
Okay. The next one, going down to page 35, man person, but right now you haven't given me anything really to prove that you wasn't inside the apartment. You know what I mean, I understand what you mean. We have some of the similar objections that we've talked about, 401, 402, 403, but we're also talking a little bit of burden shifting to an impression that it's up to Mr. Smith to prove that he wasn't in the apartment, which would be confusing. We'd submit to the jury in violation of the burden of proofs and presumption of innocence. And we would object to it on those grounds, as well as 401, 402, and 403 in due process.
State wish to be heard.
Again, Judge, it's an interviewing technique, and the part here is Detective Gibney is confronting, and to be clear, Detective Gibney is confronting Travion about Travion saying Ron did it, when he says Ron had to have told you something that happened in there, he had to have, maybe if you tell me. So again, this isn't the same thing where he's giving information about what he's found out. He's trying to flesh out what this defendant said about what Ronald Anthony did. So I think the burden shifting thing is not something that should be of concern to the jury. He's trying to elicit information again, and again, the probative value is not substantially outweighed by any prejudice.
All right. I'm going to overrule the objection on this. Again, I find that it is relevant. The probative value is not outweighed by any undue prejudice. And all right, middle of page 36.
I think it's the objections that we made last time, 401, 402, 403, due process. And
It's overruled, same reasons. All right, page 42.
42.
that says, yeah, they took my DNA last year when I got locked up and went to prison. Okay, for my first time, but I think it's perfectly acceptable for this detective to ask him, have you heard of it? He says, yeah, do you understand about hairs?
I would agree with that. We don't have any problems. What we were objecting to was the part that Ms. Shakita just said that they would be willing to pay.
All right, so the line that starts with yeah, then the line that says okay, and then the line that says for my first time. That's the objections allowed. All right, that appears to be the last one.
No, Jan, on page 48, it's similar, sort of similar. What's this? It's just they did DNA last year, which is only. It's just the DNA.
Wish to be heard.
Which I don't think that indicates anything from which a jury might think anything.
Right, I'm going to overrule that objection. Perhaps references an encounter with police, but it doesn't. I don't think that the prejudicial value of that statement outweighs probative value.
We note that it was based on our previous reasons as well.
Yes.
Objection for the record.
All right. And Ms. Brown, are you aware of any case law that on these matters that I have under advisement, they all relate to narratives of third-party statements that are incorporated within questions of interviews? Aware of any case law that provides any guidance to the court on?
The best that I can cite right now, which I will omit, is not directly on point, but it has some relevance, is State v. Carlos Kennedy. It's a 2002 case, March of 2002. In that case, what happened is, in order to show what an officer did next, they relayed a conversation that they had with to the jury, and conversation they had with a inmate who basically talked about a third-hand conversation they had with the defendant implicating himself. The court ruled that, wow, that's a normal technique to get out information to show what the police did now, that was unduly prejudicial. And I don't have any cases specifically. I have done a little bit of research in it. I would be willing to do at least a few more minutes of it. I do have my evidence books that I did not have yesterday, and I was working on it with me now.
All right. And does the state have any case law?
And Judge, I didn't know that this was getting to issues.
I understand.
Permission to do that. The bigger issue for me is I have three of the things that we talked about marked, but I don't know where they are specifically in terms of time frame. So I would need, whenever your ruling is done, I would need some time to make sure I know where these things are. So all of that being said, I don't know if Your Honor wants to give us a little bit of leave to do that, or how you want us to approach this.
Right. What I'm going to do is go ahead and take a recess now to think about this issue a little bit, probably about 15-minute recess. And perhaps during that time, you can go ahead and start identifying those places so that depending on my ruling, you'll have those items flagged if you can go ahead and do that.
I know, but I'd like to maybe get some information to give to you too. So I will do my best to do both of those things.
Okay. That's fine.
Okay.
All right, we'll take about a 15-minute recess, and then we'll regroup and see where we are in this process, and I may have some further questions for you. We'll go from there. Yes.
I know that you're also asked to keep this on our radar. And I would like to be able to give that to the state.
All right, very good.
Thank you.
Okay, thank you. All right, so we'll be in recess until 25 minutes till.
Superior Court stands in recess.